box if you can. Brilliant, that's great. Thank you very much. Welcome to the Data Basics October webinar, and what we're looking for today and going to discuss is the take on the proposed UK data protection law reforms. I'll just apologise now, my internet has been a bit unstable this morning, so I'm not going to activate my video. You'll just have my voice just to ensure that you continue to hear me all the way through. So the government released a consultation paper in September that proposes changes to the data protection laws in the UK following our exit from the European Union. And what we'll be looking to do today is to just take you through some of those changes, some of the ones that have caught our attention, and share what they look like. And then just really to reflect on what they might mean for businesses, what that might mean for what you're doing around your data protection, and how much you need to keep an eye on it. So moving on. So for those of you that haven't met me before, my name is Regina Johnys. I'm a co-founder of Data Basics UK with Kelly, who normally does these webinars. She's on leave this week, so I've stepped into the hilt. We're both experienced data protection experts. We're really passionate about providing practical advice and guidance. So really making sure that you can understand how you can take the requirements that data protection legislation puts on businesses and organisations and really make them work for the way that you operate, rather than it being seen as something that's an additional burden. So obviously when changes come afoot or suggested, we like to keep an eye on those, and that's why we thought today's webinar would be useful for people. So the consultation is called Data, a New Direction, and what the government are looking to do is to capitalise on the fact that obviously we've left the European Union, and that means that we have that degree of ability to make changes to legislation that steps away from the whole of the membership. So GDPR was a EU law that was brought across into the UK as we left Brexit, and is now referred to as the UK GDPR. And it sits alongside the Data Protection Act 2018, which was introduced to update the 1998 Data Protection Act and make sure that there was then the cross references to the new legislation that was introduced back in May 2018. So what this consultation is looking to do is to establish people's thoughts and feelings around particular areas, and what they've indicated is that they're looking to try and alleviate some of the confusion, the burden that GDPR has placed upon businesses, and the perception that it is highly bureaucratic. So they've set out some aims and principles within the consultation. They want to maintain high data protection standards so that our individual data is protected, that it's not putting information at risk, but it's trying to get away from those perceived barriers of businesses that want to use data responsibly and benefit from the opportunities that data brings when it's used correctly. And that's what they're trying to look to balance with this new legislation. They want to make sure that businesses who are innovative have got new thoughts, ideas of exploiting some of the data that we have available to us today, and that can bring genuine benefit to us as individuals around new technologies, new treatments, new understanding about the way things work, really enabling businesses to be able to use the data that's available to them, but in a responsible way, and again, mindful of individuals' privacy as they're using it. And there's a key that they want to proactively maintain public trust in the use of their data. And I think there's a recognition that without trust of individuals in the way that data is used, then it's not going to be successful, because people would be concerned about how their data is being used and the impact on them. And you can kind of see that if data is used without people's knowledge, or there's things that are done in the background that people are not aware of, it begins to erode that trust. So transparency is going to be key. And ultimately, the idea is to support growth, economic growth for the UK, and be of benefit to us as citizens of the UK, and be a world leader in data and technology. That's certainly what the principles behind this consultation are. So picking up on some of the key suggestions that kind of jumped out at me in it, there's talk of replacing some of the current accountability and governance requirements that are in place with what they're referring to as a privacy management program. Now, what that looks to do is to remove the need for certain organisations to have a data protection officer. So that's public bodies, and dependent on the type of processing you're doing, there's a requirement legally to have a data protection officer in place. So that would be removed. The need to do this sort of specific data protection impact assessments as they're set out, and removing that register of processing activities. So it's trying to remove the legal requirement to do some of these things. But then in terms of what it's replacing it with, for me, it doesn't actually look too dissimilar. So what they're suggesting is it would be a risk-based approach. And the privacy management program essentially is a compliance framework which would look to cover roles and responsibilities around data protection within the organisation, very clearly setting out that senior management would have engagement in the program, that there would be an individual who is responsible for leading that program within the organisation, that there would be internal data protection policies and processes around things like how you manage breaches, subject access requests. So all those things that you currently have in place, I hope, would remain, but sit within this privacy management program. It would sit within a context of having organisational risk assessments. So rather than potentially looking at where you look at a data protection impact assessment, you're looking at new processing, you're looking at the way in which specific systems are working. This is moving more to an organisational risk assessment. Obviously, then you'd be wanting to delve deeper into particular areas where you'd be more worried. And there is reference to personal data inventories. And for me, I think, if you talk about removing, in the other one, the register of processing activities and bringing a personal data inventory, it's probably relatively similar. It talks about the same things that we cover at the moment in terms of what data you're processing, where it is, who has access to it, what it's for. And I think the reality of it is you can't assess the risk of your data protection and the risk of privacy to your organisation if you don't understand what personal data you're responsible for. So for me, I think it looks like they're trying to make it more flexible in its approach and allow organisations a bit more freedom in how they assess the risk and how they then balance their actions against that. But there's still going to be, it doesn't remove the need to have consideration around data protection, privacy, what you're doing and how that impacts on individuals, and the risk to your own organisation in terms of the data that you're responsible for and that you're collecting. So this was quite an interesting one for me, legitimate interest, and it's something that I think has been one of those, it's a bit of a grey area in terms of the legislation. It's open to organisations currently looking at what's the most appropriate lawful basis for us to be using when we're processing personal data. It's sometimes used by many organisations as a bit of a catch-all. It's if they don't necessarily think or want to go down the consent route, then legitimate interest will sort of be the default option. And there's the requirement to do a balancing test, but some organisations may be more cautious and then go down the route of consent. And that can sometimes, there's the perception, certainly in the way that the government have framed it, to say that actually it's an unnecessary request for consent. And then individuals and people get fed up with that. They get fed up with being asked for consent to process data. So what they're looking to introduce is a kind of more clarity around that, so that there would be a whitelist of particular circumstances and processing activities where legitimate interest could apply as a default, so that you then wouldn't have to undertake in these circumstances the actual balancing test. So it would allow there to be some uniformity across organisations to know that they're looking at things like internal research and development, product safety. If you're looking to monitor and develop, if you're looking to develop algorithms and artificial intelligence, making sure that there's no bias in those, all of those they're suggesting should come under that that scenario where legitimate interest can be applied as a default, similar to some of the things that are already recognised today but aren't necessarily enshrined in the law. And I think that's the difference here. They'd be looking to say under a statutory list, these are where you can definitely rely on legitimate interest and you don't have to worry about doing the balancing test because that's already been established. Obviously, there'd still be the option to use it elsewhere, and then the individual responsible for data protection within the organisation would still be required to undertake that balancing test and make sure it's not impacting on the rights and freedoms of the individual. But I think here they've listened to where organisations have said that they struggle to define where the line is and whether they're going to be putting themselves at risk where legitimate interests are used if they don't go down the consent route, but also then potentially trying to prevent that everybody using it as a catch-all for things that they're not, they don't want to ask consent for. The cookies one is an interesting one, and I think it's probably the one that's had the most amount of headlines. And I think it's interesting when you then delve a little bit more into the detail of it. So all the headlines splashed around wanting to remove cookie banners and that asking for consent was annoying, and people didn't read it anyway. They just clicked accept so that they could read what they wanted to on the internet. And to some extent, I guess that's largely true, unless, you know, you're like me and you kind of, you know, I don't give consent to all the targeting cookies, the advertising cookies. And if there's too many to refuse because they're under legitimate interest, which currently they shouldn't be, I won't read the article, but that's me. And there's probably other privacy experts, privacy advocates out there who would be the same. But for the large majority of people, they will probably just get annoyed and click accept and aren't really aware of what's being asked of them. So when I looked into it, it was quite specific in understanding the fact that there are differences between cookies. So analytics cookies are very much helping businesses understand how their websites are used, how people move around them, and genuinely trying to improve and understand the use of websites by individuals, and not necessarily an individual, but the group of people who are visiting your websites. Now, what was interesting, it then recognised the difference between that tracking and profiling that happens when cookies are shared with third parties, and that they track you between one website and another website. And the suggestion here isn't to remove the need for consent necessarily across all of those cookies, but to actually say analytics cookies could be considered as strictly necessary. So that'd be likes of Google Analytics and anything else that gives you that insight into how a website's being used by an individual. To be able to place that without consent, they'd then actually restrict that to one website. So there's no ability, there shouldn't be an ability to cross-tracking or build that profile of an individual and their behaviour. And apparently this is similar to what France have in place already, that you can use analytics without there being consent from an individual. And then reporting would be on aggregate use only. So you're not actually then building up profiles of an individual or understanding that an individual has looked at a specific page, and then you look to follow them up with a specific message around that service that you're offering, or trying to nudge them into buying from you from that point. It's actually looking at, well, 33% of people go from our homepage to our services page. 10% of people just leave straight away without looking at anything. So what's the insight that's giving you about what pages are working, rather than actually pushing and marketing to people or building profiles around individuals and understanding more about them as an individual. So I think that's quite a difference. And then that should hopefully reduce the requirement for pop-up banners. And I think, when there's a lot of websites out there where they will only be using analytics, there's no kind of cross third-party advertising that's actually in place. So that would reduce, to some extent, the burden on individuals and the annoyance on individuals of seeing those pop-up banners. But then the contrast to that is bearing in mind that websites are often international. You may still get EU citizens coming to visit them, in which case then the EU GDPR would still apply, in which case then it's likely that you may still continue to need to actually present a way of individuals being able to manage the cookie consents themselves. There's also talk about the opportunity to have data intermediaries, where you could indicate to those people about how you want data to be used when you're moving around the internet, and moving back to that system that we had prior to GDPR and PECA being updated to understand that the GDPR definition of consent applied to cookies, whereby you can manage it in your browser yourself. Again, there's the question that I have around that, about how many people will genuinely do that, how many people will genuinely understand that they need to manage those consents, in which case then are those companies that are collecting and harvesting the information and building profiles about us then getting off lightly because they're doing it without knowledge, it's without transparency, and then that puts us at risk because we don't really know what's being built up about us out there. And linking then in with the Privacy Electronic Communications Regulation, there's a couple of suggestions there within the consultation around some amendments to that as well. One is looking to extend that idea of the soft opt-in to non-commercial organisations, so charities and political parties, which is really interesting in that at the moment, if you have a previous relationship with a commercial organisation, so you've bought something from them, they can then send you marketing information electronically, so via an email, about similar products or services that they have. But that doesn't extend to a charity or political parties, in that if you've donated to a charity, they can't necessarily contact you about similar fundraising requests unless you've given your consent to receive that information. It's something that a few charities we've been working with recently have struggled with, and I kind of agree, because actually, personally, I would rather have an additional request from a charity to say, you supported this cause before, we need some additional type of help for a particular program of funding, would you be interested, more than necessarily, do you want to buy another jumper in a different colour of one that you've already bought. So that for me seems to be a bit more fair towards charities and political parties, and I do wonder how much that has come because the Conservative Party were fined earlier this year by the ICO for assuming soft opt-in when they didn't have it and they weren't allowed to use it. So that's quite an interesting inclusion for me. And also the other suggestion within the consultation is to bring the fines in line with the UK GDPR. So that would increase the from the current maximum of £500,000 up to that percentage of turnover annually, which obviously, depending on the size of your company, could massively increase the amount, or the 20 million euros the exchange rate is at the moment. It's probably about 18 million pounds as a maximum fine. So it's quite significant in terms of the difference there. So again, I think there's been, with the data subject access request suggested changes, there's been a listening to some of the feedback or complaints that has come through from companies around the volume of subject access requests they may need to deal with. That it's very time consuming. Again, depending on how prepared you are, depending on the volume of data you process about individuals, it can take a significant amount of time. And where individuals can say that they want to know all the information you hold about them, then it can take a significant amount of person-hours to go through, identify it, redact it, and get it sent out to an individual. There's an acknowledgement that obviously removing the fee kind of took away that disincentive to ask for your data. It was £10 previously under the Data Protection Act in 1998, and I think you would hope it wouldn't be too much more or any different to that really if they were going to introduce it as a sort of slight deterrent for the people that are maybe just trying to cause issues for organisations as opposed to genuinely exercising their rights. And they're looking to try and eliminate any of those kind of vexatious requests. So allowing companies to look at the previous relationship they've had with an individual, if there's been anything that they could establish that there's not a genuine want to understand what data's held, check for accuracy, make sure it's in line with what's lawful, rather than just knowing that it's going to take the company a long time to deal with and therefore putting it in because they've got a bit of an axe to grind. The other element that they're looking to bring across is that idea of a cost cap for organisations in terms of dealing with the requests. So this is something that sits under the Freedom of Information Act already, and there's a limit on the amount that an organisation will spend in terms of time, and there's specific costs they can attribute to dealing with those requests in order to limit, again, the expense of actually handling and dealing with these requests for an organisation. So within Freedom of Information, I think it's somewhere around £650. So again, you can then look at maybe organisations will be able to help individuals be more specific about the nature of the data that they're wanting to identify, rather than, again, that kind of catch-all. And again, hopefully that would limit the the actual people who are not looking to exercise their rights from the data protection point of view, but looking to just cause problems for organisations. Now, in terms of us as individuals, I think it's then potentially a little worrying because, you know, depending on the fee level that we would be charged, there's you know, a risk again that companies could hide behind the fact that they believe it's vexatious. They could, you know, charge if there's no limit on the fee, they could charge a fee that then is very off-putting to people who are genuinely wanting to access their information for legitimate purposes. And again, it could put some people at a disadvantage who maybe are more vulnerable or who don't have access to that, you know, even small amounts of money to be able to actually say, well, I want to know what's going on with my data, and I believe that there's an issue that I want to resolve. And if they haven't got that support, then that could be quite challenging. So with data breach reporting, I think what the ICO feel is that they are dealing with a high volume of complaints from individuals complaining about potential breaches, and there's a lot of small scale breaches that they're having to handle, which then takes their time and effort away from some of the bigger issues where there's genuine risk to, or not genuine because there's risk to us potentially from all of the smaller ones, but where there's a much greater impact of risk to privacy for a higher volume of individuals. So what they're looking to do is to try and reduce the volume of complaints that go through to the ICO about sort of data breach reporting. And also in terms of companies, I think there's been a higher rate of reporting because they're worried about they're reporting just in case. They're worried about not reporting something that they should report, and so aren't necessarily assessing the breach in a way that allows them to clearly evidence and say, well, we don't need to report this because there's no risk to the rights and freedoms of individuals. They're more worried about missing it and then being slapped with a fine because they didn't report. So they're looking at changing the criteria. So rather than it being a risk to rights and freedoms at the moment, they're looking for it to be material risk, which again, then that begs the question for us as individuals of what additional risk does that put us at? Because if it's not a material risk, you know, there still could be unseen risk that we would want to know about the fact that that data has been breached. There could be impact on us that the company doesn't necessarily see. And if it's limited to that material risk, so whether that's financial or risk of violence, physical risk, then it could have a bigger and more wider impact. So I think it's that's a really difficult one to balance, and I think there may be better off looking to try and actually be more definite in the guidelines about what they feel is reportable and what isn't, and maybe give some good case studies around that rather than necessarily reducing the impact of the breach. Because if you think about how many breaches there are at the moment, and you know, in the news over the past sort of 3-4 months, there's been, you know, a good couple every week that are fairly significant, and then there will be obviously those smaller ones that are happening without hitting the news or necessarily hitting the ICO. So I think that's a really interesting one to balance and for them to manage. Thinking then a little bit more widely, there's sort of thinking about international data transfers and then subsequently adequacy agreements. Again, there's a move here really to try and make that more fluid. And I think, again, recognising the fact that, you know, we are in a global market at the moment, and data is key to you know, with all the different cloud systems and opportunities and the way that companies work together around the world, it's really difficult, as I think the invalidation of Privacy Shield showed, that huge amounts of data, particularly between us and the US, was flowing freely using Privacy Shield, and then that was invalidated. And I think what the government are looking to do is to try and keep that data flow going whilst at the same time recognising there needs to be that protection. So they're trying to make it more flexible, and they want it to be sort of proportionate to the risk. So it might be that they look at how can you make that assessment around what the data is that is being transferred internationally, and then actually how can you get countries working together to make sure that there's a way of keeping that data flow going. So things like the international accreditation schemes, so that's both UK on and allowing non-UK bodies to produce accreditation schemes that then would be recognised by the UK, allowing organisations to develop their own mechanisms. So at the moment there's mechanisms that are set in the legislation around things like binding corporate rules or standard contract clauses. And, you know, if you're writing binding corporate rules, you have to get those approved by the ICO. You know, there's standards in place that have to be adhered to, whereas this would allow organisations to look at what they could do themselves and to make those agreements themselves without necessarily needing to get that approval centrally. Again, there's positives and negatives to that. You think that those organisations who want to maintain good data protection practices and ensure the privacy of the data subjects whose data they're responsible for will create good standards, they'll create good mechanisms to ensure the safety of the data, but it potentially allows those who may have more nefarious designs on our data to operate without quite so much scrutiny, which again we have to ask, does that open us up to risk? So it's, I guess, the level of flexibility and what oversight and you know, what would the basic minimum standards be there to allow that data to keep flowing, but without putting us at risk where data goes to countries that maybe don't have the same level of data protection that we do. And that links in then again with the adequacy agreement. So there's not that many places that we do have adequacy agreement with. We've pulled across the ones obviously that the EU have an adequacy agreement with, and obviously are then looking to make our own adequacy agreements, again, that allows data to flow without needing to worry about the international data transfers, because it's been deemed that that regime is sufficient to protect the data in the same way that we would. So the aim of this is really, as they've stated, is to make the UK the most attractive data marketplace in the world. So seeing it as a real selling point for us as having great data that's available to people to work with, to interact with, to maximize, understand, and, you know, to store data here and to be able to share it. They want to take, therefore, again, a risk-based approach to adequacy agreements. So looking at, you know, as more and more countries are using the GDPR as a kind of benchmark and introducing similar data protection frameworks, being able to pull those countries in and recognise the fact that they are looking to operate in a way that is similar to the GDPR, and then looking at being able to introduce a way of working with countries sort of as a framework where they're signed up to an agreed way of working, that actually, rather than trying to do an adequacy agreement with each one, that we could look at a joint adequacy agreement. So again, looking to smooth that process to try and enable that free flow of data around the world. And again, I think it's then understanding what are the risks associated with that, where are those countries that there may be additional risk to individuals if data was to be stored in them, how is that assessed? So that will be a really interesting one to watch. It's obviously one that organisations don't necessarily have much sway over because it will be agreed nationally, but I think it's then looking to, it would be of benefit if there were more places that data could flow freely and you don't have to worry about making that assessment yourself. It's been done at a central level, but mindful of the potential ongoing risks. There's obviously then the flip side of that obviously if our data protection framework and legislation moves too far away from the GDPR as it stands in the EU, that we would risk losing our adequacy agreement, and then that's a significant number of countries that we are closely trading with and closely working with, that potentially could make it more difficult for us and customers of ours to then transfer data over to us. So I think that's going to be a very difficult balancing act for any changes in legislation to move significantly away from the GDPR. And then with the role of the ICO, I alluded to this a little bit with the data breaches, but what they're looking to try and ensure is that they've assured that they will remain independent of government, but that they should be able to focus on serious threats to privacy and public trust rather than handling the high volume of complaints that they're currently looking at from individuals. And I think that's quite interesting. I think the GDPR brought in an increased awareness of our data protection rights across the population. People are more likely to make complaints, and we've seen that coming in, with people and clients that we've been helping around complaints around privacy policies, complaints about how data has been handled. And largely, I hope people are going to organisations first, but if there isn't a good response, then they will go to the ICO. And I think this is where the frustration is coming in, because the ICO are then trying to deal with a lot of small complaints, which is hard if they haven't got necessarily the manpower. So to facilitate that, this consultation document is talking about trying to enforce a route that individuals would have to go to organisations first, and to facilitate that, organisations would have to implement clear and transparent complaints processes around privacy and data protection, so that they could deal with those complaints from individuals and hopefully keep the vast majority of them in-house, sorted, resolved, as opposed to then going to up to the ICO. So again, that will be quite an interesting one to watch. The ICO have broadly welcomed the consultation, from what I can see, but have obviously highlighted the fact that it needs, whatever changes are made, it needs to bring the public with them. It needs to ensure that the trust and the protection of individuals is key, because without that, then it sort of becomes a bit of a wild west for data, and that's not going to end in a positive way. So some of my reflections, I think, as I've just alluded to there, trust is key. Without individuals and us as citizens trusting in the way that organisations are handling our data and the government is handling our data and protecting us through the legislation, then people will be wary, people won't want to give information across, and will feel suspicious of organisations. So I think there'll be a real kind of test of who are those organisations who are wanting to maintain good data protection standards versus those who may use this as an opportunity to try and get away with the bare minimum even more. As I mentioned, if there's any substantial perceived weakening of our standards and the protections that we offer to individuals and the way that other citizens' data stored here would be, so from the EU, if their data is stored here, they need to be assured that their data will be treated in the same way and with the same level of protection as if it was in the EU. And any weakening of that does risk our own adequacy agreement. So that was agreed earlier this year, and I think it was scheduled for review in a couple of years' time. So this could be, it's a very fine line to tread, and it's something that the government are going to have to make sure that it doesn't put that adequacy at risk, because of the number of countries that would immediately make difficult and bring into the need for them to agree international data transfers with us could be hugely time consuming for businesses and add additional burden where there's already those additional burdens around export, trading, paperwork that has been not particularly popular since we left the EU. I'd say that the additional clarity that is trying to be brought in, particularly around things like legitimate interests and where that's relevant to be used and not, is likely to be welcomed by businesses. Certainly, people that we speak with often sort of worry about those grey areas and sometimes want sort of a bit more of a hard and fast line about what's right and what's wrong. And so I think where that is being introduced, that could be quite helpful for businesses and at least allow them to have those sort of case studies around, well, if it's here and we're doing something similar, then we could probably rely on that as well. So I think that's something that, again, with time, as GDPR beds in, and then whatever we do here, that will be something that helps businesses to make those decisions a little bit quicker without worrying about the potential to make a mistake. And I think that's what a lot of businesses are worried about, the potential to make a mistake when they make those decisions, whereas actually if they can justify the rationale often, it would just result in a change. I think there's a real need to keep an eye on that balance the challenge of compliance, and it is challenging. You know, the bigger organisations will often have huge teams, and it can put a difficult burden on smaller organisations. But it's always about what's reasonable and what you can do, and the nature of the data that you're collecting, as to the extent of what you need to put in place. And I think that message will need to come through this and any changes to the requirements, that it's not an easing of standards, it's not, you know, a free-for-all now. It is still the need to protect personal data, but that there's a recognition that it has to be a balanced approach, and that organisations of all different sizes need to be able to do this practically. So it's not a tick box exercise, and we talk about that, and this document talks about that it's just moving away from, we've ticked a box, we've put a privacy policy on our website that doesn't really say what we do, but it's there. You know, you actually want something that shares the, you know, that protects the data, that works for your organisation, that your staff understand, that your customers and your stakeholders understand, and actually it's proportionate to the level of risk that your organisation is facing. So I hope it will, if that kind of change comes in, it will actually be of benefit to the vast majority of organisations. The one thing I do worry a little bit about reading is it could make it easier to hide mistakes. So if the sort of criteria for breaching drops, reporting a breach drops, sorry, or, you know, that people feel that they can get away with more, or that they can do more with people's data without being as transparent because, oh, it's down to the individual and they haven't said no. Actually, it's because potentially you haven't made it easy for them to say no. So how do you continue to make sure that those organisations who want to use data in a way that isn't good for privacy, that isn't good for us as individuals, don't get away with it, and that individuals are empowered to challenge that and to hold them to account? And I think the interesting thing again then is the public awareness and expectations, which links into that. So how do you make the public aware of privacy, to care about the privacy and their own data, and to make sure that they can take the necessary steps to protect themselves, as well as then people are more aware now of the fact that they do have rights, that GDPR is a thing. You know, prior to that, data protection wasn't something that people were necessarily aware of routinely. And so what are your public's expectations of how you handle their data, and what changes that you make as a result of this? What would the impact on their perception of you as an organisation be? And you know, is there a risk there that if again they see any loosening of how you're handling it, or what you're doing, or how you communicate with them, could be perceived as being done with not good intentions? So I think it's going to be a big balancing act, these changes, and there are any suggested changes and proposals at the moment. So it's a really interesting thing to keep an eye on. What I'd say is those organisations with good current data protection processes and practices will be in a good position. Doesn't seem to be a huge overall change. So privacy management program doesn't look different from the types of things that we work with our clients with, you know, in terms of putting in place, understanding good governance, making sure that it's something that your senior management team are engaged in, that policies and processes are in place, that risks are identified. It's just potentially that requirement and how it's legislated will shift. So I think those organisations will continue to be in a good position and don't need to panic massively about the changes. And what I would say is have your say. You know, the consultation's available for the next couple of weeks till the 19th of November. I put the link in the chat before you all joined, so if you can see it there, then that's great. If not, I will pop it in again now, just so that you can have a look through. It's quite a lengthy document, but if there's particular aspects that you are interested in responding to, or that you feel particularly passionate about or are relevant to your business, do go in and have a look through and answer the questions and have your say now, because it's your opportunity to hopefully shape the way that this can be rolled out. So we've got a few minutes for any questions if people want to pop them in the chat, or any thoughts that you have that you'd like to share around the kind of things that we've said. Possibly, I think. So we've got the question there: are data subject to access requests often from disgruntled staff who are currently under disciplinary, who just want to see what we have said about them? They are not looking at data collected or processing. Would these count as vexatious? Quite possibly. I think if this is something that comes in, there would then have to be that criteria about what can you consider as vexatious, and would there be any exemptions for things like, if staff are looking for particular things that are said to support their case. I think those are the types of, again, scenarios that would come out once this was brought in. So I think if you're allowed to consider the relationship that you've got with that individual and understand the reasons why they're putting it in, I would say that's probably likely to be counted as vexatious. But it's, again, then whether it's held up in law that they can and have the right to see the information that relates to that disciplinary. So it might mean that what you'd have to give them might be slightly less. So it wouldn't necessarily be everything as it would be at the moment, but you could, it maybe might be just specifically relating to a disciplinary circumstance or the decision that's been made. But I think that's something that would come out in the wash after that change was introduced. Any other thoughts? Do you think it's a good kind of changes? Do you think that they're not substantial as you expected, more substantial? What thoughts does anyone have on that they're willing to share? Or is it all kind of yeah, well, if the soft opt-in, if they extend that to charities, they would be able to legitimately use it, whereas they can't at the moment. So I think at the moment, some do risk it. They see it as a bit of a trade-off. I think others don't and want to try and get that consent, but really struggle, particularly with their historic databases. So, but yeah, if the fines, I think what it might also do, it might make those kind of marketing campaigns where we've seen the likes of, in the last few weeks, there was fines for companies who'd sent out millions and millions of text messages, spam text messages, and only been fined, a few 100,000. And actually, in the grand scheme of it, in terms of if they got a very small percentage of responses and sales from those text messages, it probably completely wipes out the fine anyway. So that might be a positive thing, I think, in terms of promoting our rights over how marketing data is used, particularly where it's coming in SMS, telephone. And I think the other thing that I noticed in there is that they were looking to change the way in which unsolicited marketing telephone calls were reviewed when they've been done in a way that's not compliant. So currently it's calls received, so where people have picked up the phone, whereas I think they're looking to amend that to calls sent. So they can then, obviously that's likely to be larger, particularly if you've got the automated phone call systems and things like that. So that could again then be quite a difference for some of those bigger organisations who probably the fines are not too much of a disincentive to continue their bad practices and annoying people with unsolicited phone calls. I can see another question coming in. Yes, I would agree with that. The concern around, I think the biggest concern around these changes, there's two big concerns for me, I think. I agree with you around the potential to upset the EU Adequacy Agreement. I think the impact on British business would be huge, and British academia and research, because of the nature of the data that's shared across all of those sectors. It needs to flow freely. And I think, they are the closest trading partners to us. There's a lot of collaboration and work and trade that goes between the EU and the UK, and therefore there's going to be a lot of data that follows that and enables that and underpins it. And I think that is a huge risk, and I think it's something that obviously the EU are watching quite closely, because this document came out not that long after the Adequacy Agreement had been given. But I think it's something that really has to be considered, because if it makes it additionally difficult for British businesses to do business with the EU businesses, and similarly across, collaborate across academic institutions, research institutions, it will make life a lot more costly, a lot more challenging, and be prohibitive to the aims of this consultation. You know, they talk about wanting to make us a leading marketplace for data, you know, and to enable the free flow of data and collaboration, and recognise the fact that that's a positive thing for the UK. So moving too far away from the GDPR, which is seen internationally as a gold standard and a bit of a benchmark, you know, a lot of the countries that are introducing data protection regimes are using the GDPR as a basis for that, and combining it maybe with other ones that are more local to them. So I know that there's quite a few of the East African countries are using GDPR and the South African data protection legislation as a sort of a mix to create their own data protection legislation. So it's something they have to be really careful as they implement that. And then for me, the other significant worry is the protection of individuals' privacy, and ensuring that individuals are aware and know about how data is being used, particularly if there are elements where we currently should be giving consent and can give consent or refuse it. If that's moved away and taken to something like legitimate interests, or it just, without that information, without that easy way of managing it, it becomes much more difficult, because a lot of people won't make the effort to look and investigate and understand. And so if that's the majority of people, then it puts everybody at risk. So I think it's a really difficult balance that they'll need to try to fine line about how many changes they make, and to make sure that privacy is protected by the privacy of individuals is still protected and upheld by the majority of organisations in the country. And there will be privacy activists that will be watching this, and they will be challenging aspects that they feel put our rights and freedoms as individuals at risk. And so I think it's going to be a very interesting space to watch over the coming months. Excellent. Are there any other thoughts that people would like to share before I just finalise? If you've got anything that you'd like to share beyond the webinar, please do get in touch. If there's anything specific, have a read of the document, and it's on the government website. If you Google data a new direction, then you will find it, and have a read and give the feedback. So just to finalise a few points, we do have in the new year our next round of the Diploma in Workplace Marketing, Workplace Data Protection, coming up. It's a 5-module course that will take place between January and April. If you'd like more information about that and how it could be useful for your HR teams, please do get in touch with us. We can obviously help if there's anything that you feel you've got a gap at the moment. We can deliver training for your staff. We can act as a data protection lead for your organisation, and we can help you understand where you currently are. We've got a free catalogue, so you can have a flick through. It's available at that download link. Have a look through what we offer. Our best practice groups are really popular, and there's a few members on here today. It's a really good opportunity to come together with other people who care about good data protection and understanding what they can do well, and what the challenges are. And it's a really confidential discussion with us. It's not all about our knowledge, it's about sharing that best practice from across the room. And we have places on ones that are kicking off again into the new year, so please do get in touch if you'd like more information around that. And finally, there are all of our socials. We have lots of useful hints and tips on there, keep you all up to date on what's going on, so please do have a look at those and keep in touch with us. It's been a pleasure having you with me on the webinar today. I hope you've enjoyed it. If you do have any questions, please ping me an email. I'm very happy to answer them. And if you want to pick up on anything, then please do look at our YouTube channel. We've got our previous webinars there, and you are able to see this one when we upload it, probably next week if you missed anything.